of individuals who engaged in misconduct at the Justice Department and retired on the eve of us questioning them. And then they don't come in. And valuable evidence is lost. Sometimes they are the subject. Sometimes, frankly, they're the critical witness.
Right.
They retire, they have their pension, they move on.
Yeah.
And in fact, actually, if they become contractors, they can come back and work for the federal government, and we can't subpoena them in that position. Okay. How did all of these failures in the FISA process that's layered with all of these controls happen, and why? Our review, as we made clear here, is about the Justice Department and the FBI's handling of the opening of the Crossfire Hurricane investigation and the Carter Page-related FISAs, along with the FBI's activities on their confidential human sources and surveillance that the FBI did. Oversight by these officials required greater familiarity with the facts than we saw in this review, where time and again during OIG interviews, FBI managers, supervisors, and senior officials displayed a lack of understanding or awareness of important information concerning many of the problems we identified. That is why we recommended that the FBI review the performances of and hold accountable all individuals, including managers, supervisors, and senior officials, who had responsibility for the preparation or approval of the FISA applications, as well as the handling of the Woods procedures. We found that investigators failed to meet their basic obligation that the FISA applications be scrupulously accurate. We identified significant inaccuracies and omissions in each of the 4 applications, 7 in the first FISA application, and a total of 17 by the final renewal application. As a result of these significant inaccuracies and omissions, the FISA applications made it appear as though the evidence supporting probable cause was stronger than it actually was. We also found basic, fundamental, and serious errors during the completion of the FBI's factual accuracy reviews, known as the Woods procedures, which are designed to ensure that FISA applications contain a full and accurate presentation of the facts. Department lawyers in the court should have been given complete and accurate information so they could have meaningfully evaluated probable cause before authorizing the surveillance of a U.S. person associated with a presidential campaign. That did not occur, and as a result, the surveillance of Carter Page continued even as the FBI gathered evidence and information that weakened the assessment of probable cause and made the FISA applications less accurate. We concluded that as the investigation progressed and as more information was gathered to undermine the assertions in the FISA applications, investigators did not reassess the information supporting probable cause. Further, the agents and supervisory agents did not follow or even appear to know certain basic requirements in the Woods procedures. We also did not receive satisfactory explanations for the errors or the missing information and the failures that occurred. On evidence, but it's pretty clear from what we're laying out here that the FBI is, from day one, was asking questions about the corroboration for the Steele reporting and not getting it. So,
and it was known immediately by FBI at that point that there was zero corroboration for this. In fact, the State Department personnel, even when they met with Steele, noted that he had his facts wrong, even what he was presenting at that point, and they knew it all immediately.
They referenced, I think it was the purported Miami consulate, that there was no such Miami consulate.
All right, thank you. Thank you, Mr. Chairman.
So, Senator Langford.
We had 2 witnesses who would not speak with us, Mr. Simpson, Mr. Weiner, and we had no ability to get their testimony. Most importantly also, though, partly the reason this took 18, 19 months is because many witnesses initially declined to speak to us, and only towards the end of the investigation re-engaged and said now they were interested in speaking with us, turned down their testimony.
Right.
That required us to extend our timing. So having subpoenas not only would have allowed us to get evidence we didn't get, but it would have allowed us to move this more rapidly to a conclusion. Grant recipients, contractors of the federal government, those are people who are not federal employees, who don't have an obligation to cooperate. That would be very helpful in that regard. Former employees, I could go over and over and over with you, and we've sent many examples to the committee, of individuals who engaged in misconduct at the Justice Department and retired on the eve of us questioning them. And then they don't come in. And valuable evidence is lost. Sometimes they are the subject. sometimes frankly, they're the critical witness.
Right.
They retire, they have their pension, they move on.
Yeah.
And in fact, actually, if they become contractors, they can come back and work for the federal government, and we can't subpoena them in that position.
Okay.
So there's a lot of reasons why that's a very important provision. And by the way, the Defense Department IG has that authority.
Okay.
It's been used very sparingly in all the years, because when you have the authority, people work out a voluntary arrangement
Right.
to come in and talk.
Right. Of course.
How did all of these failures in the FISA process that's layered with all of these controls happen, and why? And I know that's a big question for people to know an answer to, and I understand why. But you know, at this stage, that I think we didn't get good explanations about, and that was something we frankly would have liked to have gotten good explanations about.